Good morning, and thank you very much to Ines for this introduction. So I would like to thank Justice Zineta Ziemele and Ines Freimane for the invitation to this conference. It's a great honor to be here at the Riga Graduate School of Law. And the title of my presentation is on the screen, the three main constitutional cultures in Europe towards uniformization or retaining diversity. It might be useful to start with a couple of words of how I got to this topic. So in my early work, and also in my PhD thesis at the EY in Florence, I looked at constitutions through the lens of sovereignty, which is a traditional lens. And I found, also in a monograph published by Cambridge University Press, that the Central East European constitutions are more sovereignty protective than West European constitutions. I call them sovereignist. However, over the years, I increasingly developed a sense that sovereignty is a somewhat limited perspective, and many important issues, also regarding fundamental rights protection, tend to be absent in the mainstream European and transnational discourse, although they are important at the national level. And I wrote some of these concerns down in my two-part article on erosion of constitutional rights in EU law, a call for substantive cooperative constitutionalism. It was published in the Vienna Journal of International Constitutional Law as a two-part article, and it is also available open access on the SSRN. And later I will refer to this piece as the Vienna article. And so in the last few years, I have been delving deeply in depth. I've been almost immersed in the study of national constitutions and EU law and the dynamics through the large comparative research project, The Role and Future of National Constitutions in European and Global Governance. It's a 5 to 6 year project. And it was funded by a 1.2 million euro grant from the European Research Council. As part of the project, we have 29 national reports, which were written by leading constitutional law scholars, and some of them are here, also Professor Tuomas Ojanen and Professor Monika Klaes. These will be published. They have been heavily delayed, but we now have the second proof, which we are checking, and as soon as we send that back to the publisher, it will be published, so hopefully middle of May or at the latest end of May. And the Latvian report was written by Professor Kristīne Krūma, who was the former justice of the Latvian Constitutional Court, and her colleague Sandis Statkus. As you know, sadly, Kristīne Krūma has meanwhile passed away, and I wrote an in memoriam note to the Baltic Yearbook of International Law, and also for this book for Kristīne. And I'll come back to the Latvian report later. I think it is highly interesting and contains material that is not widely known in Europe, especially about the very high standard of constitutional review by the Latvian Constitutional Court. And the reports look at different areas. They have three broader parts. And so they look at the traditional area of constitutional amendments for European integration and international law, and also at the areas where there has been strain on fundamental rights and rule of law safeguards in the context of EU law, such as in the context of the cases regarding European Data Retention Directive, not to be confused with the more recent Data Protection Directive, and also European arrest warrant cases, the balancing of fundamental rights and market freedoms, the IMF and EU austerity cases and social rights and other fields. And I should early on make a note that there are many areas where the EU has made an important, very welcome contribution to fundamental rights, especially as regards non-discrimination, gender equality, environmental protection, But there are also scholars who observe, and there's a classic article in particular by Koppel and O'Neill in Common Market Law Review, which point out that the Court of Justice has a different mission, and often these cases are used in a way that allow to advance the scope of EU law vis-à-vis the member states, but that the Court of Justice is lax with regard to EU institutions and their acts in terms of judicial review. And so I should also, before I go to the material, I should emphasize that the project does not concern the more recent illiberal trends. So I won't be speaking about what is happening in Hungary, Poland, or Romania. The reports look at the material before 2016. The Hungarian report is about the liberal developments, but the Polish report is written about the material pre-2016, and so in this study the Polish constitutional law is still included in what I will later call the post-totalitarian constitutional cultures. And so what we are looking at is the deeper comparative European constitutional culture, the common and diverse elements, and how these have been changed by EU law and also to some extent by global governance. One of the broader findings of the project is that we are in a gradual process to transition to not only uniform but autonomous European Union constitutional law. And in the presentation that follows, I would invite you to bear in mind this nice quote from Professor Anneli Albi from University of Copenhagen, who is a lawyer linguist. And she asks, what happens to law if we have self-referential English language European legal discourse with, by and large, no references to the domestic laws of the member states? And I have come to form the view that the prevailing narratives on sovereignty and also the lens of Euroscepticism and Euro-friendliness through which constitutional courts in vast majority of the literature have been assessed, to some extent mask a lack of understanding of comparative European constitutional law, and possibly at times also a deliberate quest to displace comparative European constitutional law. And interestingly, there is an article by Antoine Vaucher in European Law Journal where he looks at EU funding which has been directed to specifically study the autonomy of EU law and to direct it away from the study of comparative European constitutional law. So with this in mind, what then is happening to constitutional law? In the project, we looked more at substantive comparative constitutional law. I think the focus has often been on ratification procedures and the like, but we looked more at the Bills of Rights, the domestic understanding of the rule of law, judicial review and its statistics and grounds, the constitutional amendment culture, and other factors. And on the basis of these, I divided Europe's constitutions broadly into three broader categories, which are on the screen. And these are the political historical constitutions, post-totalitarian, post-authoritarian constitutions, and traditional or legal hybrid constitutions. And I will now explain the main differences in greater detail before I then, in the second part, come to the broader changes through EU law. So first, there are what different scholars describe as the political or historical constitutional cultures. And these are the UK, which has an unwritten constitution, and the constitutions of Malta, the Netherlands, Luxembourg, and the constitutions of the Nordic countries, Denmark, Sweden, and Finland, and also the Swiss constitution, which is part of the project, is in this group. In these constitutional cultures, the priority belongs to parliament. I think they reflect more the French Revolution and Enlightenment idea that people are the supreme representative of, hold the supreme power represented through the parliament. And there is either no constitutional court or it is of a weak type, as in Malta and in Luxembourg. There are either no annulments of laws or occasional declarations of incompatibility. Or annulments are rare. For example, in Denmark, only one law had been declared unconstitutional until 2015. Importantly, for this conference and for the transnational discourse, rights protection typically takes place on the basis of a historically older or more generic Bill of Rights, which has limited justiciability, or on the basis of the ECHR. There are some exceptions, such as Finland's more recent catalogue of rights. These constitutional cultures are more pragmatic and flexible, and they are ambivalent regarding the supremacy of the constitution. Partly, as in this type of constitutions, change is reflected gradually ex post facto. And courts are described as deferent to political institutions. The impact of EU law and of the ECHR is that they have enhanced the protection of fundamental rights, judicial review. They have also enhanced the protection of the general principles of law, and they have increased the power of courts vis-à-vis parliaments. These cultures are widely seen as having become more juridified and in that sense more Europeanized. However, where a sense of loss is felt is in democracy, and especially in the UK, and this was possibly also part of the reasons that led to Brexit, there was a sense of lack of democratic responsiveness and the distance of the decision-making in Brussels and lack of accountability. Britain has a very vivid and in-depth and really precise democratic discourse, and at the EU level, inevitably, things become more generic and watered down, and the debates, and it is not clear who to address. In Denmark, the foreseeability of law has been problematic in the Danish, and the Danish Supreme Court in the Ayers case questioned the far-reaching teleological interpretation on the part of the Court of Justice. For the Nordic countries, obviously Viking and Laval have been to some extent problematic, and there have also been issues around transparency in the EU system. And Viking and Laval are also examples of one profound way out of many in which the EU to some extent changes the logic of protection of fundamental rights, which is that in these cases fundamental rights became restrictions on the market freedoms, and these restrictions must be interpreted strictly. So whereas in classic constitutional law priority is given to fundamental rights, through these cases fundamental rights become restrictions which must be interpreted strictly. I would also say about Viking and Laval, coming from Estonia, that they are perceived obviously differently in the Baltic states for obvious reasons, but I think similar problems would arise if large numbers of workers at minimum wage were to suddenly arrive from other parts of the world to Estonia and Latvia. So I think these issues are relevant to all member states. And interestingly, I think there is a recent directive which tried to address the consequences of these cases, which also goes to show the difficulty and the time it takes, since problems are raised about an ECJ judgment, to actually resolving the issue at the EU level. Whereas in the domestic discourses, it is often pointed out that the Constitutional Court, if the Constitutional Court gets something wrong, there is an immediate domestic debate, and often the matter is then remedied through legislative process. Now, the second group on the list is the post-totalitarian or post-authoritarian constitutions. And for ease of reference, I'll call them all post-totalitarian, but obviously there are degrees of difference, and I won't go into the conceptual differences between authoritarian and totalitarian regimes. But often the divide of the constitutions is also along the East and West. And here I would point out that the post-totalitarian constitutions in the West are Germany, Italy, Spain, Portugal, and Greece, according also to an article written by the eminent Italian constitutionalist Cesare Pinelli in European Law Review. And then he observes that this tradition was consolidated by the adoption of the new post-communist constitutions in Central and Eastern Europe, although sadly Poland and Hungary are no longer part of it, and I didn't classify them for the time being, or maybe there should be a fourth category of illiberal, new illiberal constitutions. So the post-totalitarian constitutions represent the never again ethos. The countries had a history where authorities exercised power over individuals in an arbitrary, repressive, coercive manner, often based on teleological, efficiency-based arguments, and by executive decrees rubber-stamped by courts. My generation in Central and Eastern Europe, and maybe some in this audience still remember this kind of history, but younger generations no longer have understanding or awareness of this. And interestingly, some Central East European scholars have pointed out some strange parallels, and I'm hesitant to mention this, and clearly there are no more far-reaching parallels, but interestingly, Advocate General Michal Bobak from the European Court of Justice, and also myself, have observed the difficulties regarding the teleological interpretation and the focus on effectiveness, and the somewhat sort of, as I said, strange parallels. And Polish judges have specifically mentioned that they do not like the use by the Court of Justice of teleological interpretation in the field of criminal law, because they don't want to cross the same river twice. This is from interviews organized by Ursula Jaremba in a book on Polish judges. And so the constitutions have what I have identified as 12 core features. The totalitarian constitutions were fictional or political, and so the post-totalitarian constitutions have a strong binding normative force with extensive and detailed fundamental rights and rule of law safeguards. And importantly for this conference, and it was surprising for myself and for the co-editor, often these rights, Bills of Rights, go actually a lot further than the ECHR and also the European Union Charter. And at times they are quite possibly, I have suggested in the book, the most advanced written and judicially protected fundamental rights, social rights, and rule of law safeguards in the world. But they have increasingly and surprisingly come under strain in different contexts of EU law. I have brought lots of examples in the erosion of constitutional rights article, which I mentioned before. One area was the EU Data Retention Directive, which essentially introduced mass surveillance. And this was hugely problematic, especially in Germany, but also in Czech Republic, Slovakia, and later on in Ireland and Austria. Of course, it evoked parallels from the pervasive state surveillance that prevailed in eastern part of Europe until very recent times. And interestingly, the Court of Justice at first, in the first challenge, upheld this directive, but only after there was a lot of fuss in different member states. Then in the second case from Ireland and Austria, the Court of Justice eventually annulled this directive on fundamental rights grounds. And it was only the first ever directive that has been annulled on fundamental rights grounds. And it also shows the importance of national constitutional courts and national litigants to raise these issues because, as I said, had there not been a second round, this directive could still be in force. I also extensively documented in the article challenges regarding the European arrest warrant. There was the famous Belgian advocate in the Verelt case on the nulla pena sine lege, which is a very classic comparative European constitutional principle. And one area that is strongly protected in post-totalitarian constitutions is judicial protection. I have written down some of the provisions, typical provisions. There are many differences and exceptions. And where these became particularly acute have been the cases, and this is a comparison from the EU Charter. And so there have been cases where people have had strong, compelling evidence of their innocence, but they have nevertheless been extradited because EU rules do not allow national courts to carry out judicial review. And here is a British case which was widely reported in the media. Andrew Simeo was a British schoolboy who was extradited to Greece and spent a year in high security Greek prison with very bad conditions. And this is an Estonian gentleman. Estonia didn't have arrest warrant debate until this case in 2012. The gentleman, Neeme Laurits, was extradited to Finland, which is much nicer than the Greek prisons. But he felt that it wasn't just about prison conditions. He felt that his treatment of not carrying out any judicial review of compelling evidence, and there was an interview in the media, he said himself that it was similar to Soviet times, that judges didn't provide any judicial protection. And the judges were then also interviewed, and the judges said that, yes, indeed, in Estonia, the rule of law would require judges to carry out some level of review, but they were bound by supremacy of EU norms. And so this is one controversial example. Interestingly, I read from the Latvian report that the arrest warrant has not been problematic in Latvia, and neither was the data retention directive, and there might be a need for a discussion, so how these slipped through the net, as it were. And coming to Latvia, I had difficulty deciding where to place Latvia because, of course, Latvia has an older 1922 constitution, and it is described in the report as a predominantly procedural constitution. But I nevertheless placed it in the category of post-totalitarian constitutional cultures for the reason that there is a strong constitutional code which is essential to this constitutional tradition. And the role of constitutional courts is to safeguard the value order, the fundamental rights, and democracy. And in fact, the co-editor and I, we put the fundamental rights, democracy, and rule of law into the second part of the title of the book to emphasize these values, because traditionally the focus has been on sovereignty and on assessing whether constitutional courts are Eurosceptic or Euro-friendly. And this often, I think, actually shows the lack of understanding of this kind of tradition in the mainstream European discourse. What is also typical to this type of constitutional cultures is that the constitutional court's judgments predetermine the acceptable margins for political activity, and excuse me. And these constitutional courts often tend to follow the German constitutional court, especially as regards the Rechtsstaat-based rule of law safeguards, as does, according to the Latvian report, also the Latvian constitutional code. And also the constitutions tend to be amended in case of change, and this reflects the supremacy of the constitution, which is part of the idea of the rule of law. So if there is a change, the constitution is amended. Now, I think I'm running out of time. Very briefly about the third category of constitutions, which was the France, Belgium, Ireland, Austria, Cyprus. And we had difficulty in finding a good name for this broader and more diverse category. And I have to thank also Monica Klaes, who is in the audience, and Advocate General Gerard Hogan from the ECJ for helping to figure out the good name for this category. Because they have legal constitutions with constitutional courts, apart from Ireland, which has constitutional review. And Cyprus has constitutional review, but without constitutional court. But they are not as far-reaching as the post-totalitarian constitutions. They have more pragmatic cultures. The Belgian report describes the Belgian constitutional culture as an efficacy-based culture. And most of them also have older historical bills of rights, and the protection mainly takes place on the basis of the ECHR. So France, the domestic instrument of France is the 1789 Declaration of Rights and Man of the Citizen, and the Austrian Domestic Bill of Rights is quite a laconic one from 1867. And in the discourse, often scholars praise the Austrian and the Belgian constitutional courts for referring lots of cases to the ECJ and also referring to the Charter. But what is not mentioned is that their domestic bills of rights are quite old and laconic. And also the constitutional review in France was introduced later in 2008 for individuals. And also in Belgium and France, constitutional review has a slightly different purpose or rationale than in post-totalitarian constitutions. And also the Rechtsstaat-based guarantees, rule of law guarantees, are not as advanced, they're not as strictly protected in these countries as in those countries that follow the German constitutional court. And maybe two concluding remarks, if I'm allowed. Yes. So one is, I think, we should be mindful of the center-periphery dimension in the transnational discourse. And in my experience over the years, the influential agenda-setting scholars and law journalists tend to be based in countries which represent more the political or the traditional legal constitutional cultures, especially the Netherlands, Belgium, France, also Ireland, and I think Britain remains, in terms of scholarship, very important even after Brexit and influential, and US scholars have also been very influential. But crucially, when you look at the details in the cases that are covered in this project, often these scholars don't actually understand. They think differently. So many of these issues don't arise for them. For example, the ESM treaty cannot be reviewed in the Netherlands because the Netherlands doesn't have constitutional review. It is banned according to the constitution. And there are a growing number of scholars who are raising concerns about the rule of law in the EU, but they tend to be mainly from Germany, Spain, and Central and Eastern Europe, which are all the periphery countries. And the second broader note is that, as I mentioned at the beginning, we are moving to autonomous, uniform EU constitutional law. So whilst on the one hand there has been very little awareness about the differences in the national constitutional cultures, on the other hand, these are also losing their relevance because we are moving to one uniform constitutional law based on the treaties and the ECJ judgments. And what is interesting is that many scholars find that this is not in fact constitutional law, but it is a governance paradigm. And these scholars, for example, are Somek, Menendez, Mendes, Garcia, Bouza. And they find that the limits to authority and exercise of power are no longer based on constitutions, but are more vague and economic. And the decision-making is becoming apolitical. So we can receive the measures, but we cannot easily protest or change them or discuss them. And I'll just briefly mention a couple of other scholars who have made this type of observation, but in a different wording. There is the article about the end of constitutionalism as we know it by Ming-Sung Kuo, the end of the age of constitutions by Professor Simoncini. Some have observed twilight of constitutionalism. There's a book by Professors Loughlin and Derbner. And Galera and Harlow separately have observed a move towards a thin, weak procedural version of the rule of law, democratic control, and judicial review in international economic cooperation, with increasing difficulty for individuals to challenge public decisions. And so I won't have time to go into this, but I have in the Vienna article offered sketched a different potential vision, substantive cooperative constitutionalism, where the established rule of law safeguards would be retained, a role would remain for, a meaningful role would remain for excuse me, for national parliaments and national constitutional courts, and also specific suggestions have been made by project experts on how they see a more proactive and meaningful involvement on the part of national constitutions and national institutions in EU decision-making structures. And I'll just leave you with 2 slides maybe to have a look at. So this is statistics from the Latvian Constitutional Court on judicial review, and it is very stringent, and it is similar to post-totalitarian constitutional courts. Often a third of the measures have been annulled on the grounds of substantive grounds such as fundamental rights and rule of law principles, including legitimate expectations. And also Latvian Constitutional Court has upheld in the IMF cases the important principle of comparative European constitutional law, which is the parliamentary reservation of law. And this is one that has widely come under strain through EU and transnational measures. And interestingly, many other constitutional courts have relaxed their criteria and accepted the supremacy of EU law with regard to this requirement, where it needs to be relaxed. For example, France implemented the EU Data Retention Directive that introduced mass surveillance by a governmental regulation, and it was contested in the courts, but the court approved that. But so I think the Latvian Constitutional Court has made important contributions to thinking about constitutional values and rule of law safeguards in the context of European and global governance. So thank you for your attention and for bearing with me, and I would be glad to answer any questions or also disagreements that you may have. Thank you.
Thank you, Anneli. So, are there any questions? No questions? Oh, okay.
Thank you very much. I'm not sure if I'm allowed already to ask questions, but no, thanks very much for your typology. I was just thinking, coming from the Netherlands, one of the more political, softer constitutions, as you call it, if you have these 3 typologies, and if we work on that assumption, how should you deal with the fact that you have 3 typologies as an EU? Should it mean that you should allow more divergency between 3 constitutional systems? Should you respect this divergence? And would you have any thoughts about how EU law could create that space within its framework? Because indeed, from the EU perspective, the fear has always been to have too much divergence that might threaten unity. So how to accommodate this divergence? And secondly, do you see any predictive value from your typology for the kind of populist, Eurosceptic response we're seeing across all 3 constitutional systems? Thank you.
Thank you. Both extremely important questions. So in terms of what to do regarding the diversity, I think when EU law was mainly about the single market, it was not an issue, and we all appreciate single markets, and it is well established, although perhaps there were some nuances where we could have a discussion, such as the Viking and Laval cases and some others. But we are now... EU law has expanded well beyond the single market. EU law is now regulating criminal law, and interestingly, more traditionally minded criminal law scholars have started to raise important concerns. For example, there's a manifesto by 14 European criminal law scholars who say that we shouldn't see harmonization as an end in itself, and this is leading to repressive, coercive EU criminal law, which is not sitting well with classic values of constitutionalism. So criminal law and constitutional law often are closely related because many of the criminal defense provisions are especially contained in the post-totalitarian type of constitutions. And given that there is this expansion of competencies, which also seems to be in the DNA or the imprint of EU law, and we know the neo-functionalist theory, one key element of which is integration through law, which eventually sees the end goal in one uniform EU law. And Christian Jürges, Professor Jürges from Germany and formerly from the UI, has started to write about this and made a strong case for diversity. So we need, I don't have ready answers. There are lots of really interesting, worthwhile proposals in the national reports on what could be done. One is simply Court of Justice leaving more deference or more space for the national courts to decide. Another one might be to introduce constitutional amendments within member states to not only to open up the EU law for EU law, but also to set conditions under which the EU should operate. And one very practical proposal was made by the Maltese constitutional law expert who later on became a judge at the Court of Justice, Peter Schörab, and he recommends that the current, what is known as the yellow card mechanism for national parliaments should be expanded beyond the scope, beyond the grounds of subsidiarity and proportionality to include all key or profound or more important constitutional grounds. So that might be one way to bring them more into the EU discourse. And in terms of the second part of your question, the recent surge in populist movements, colleagues have started to make remarks which I share, that for a long time it was not possible to put forward or discuss alternative visions to the European Union. And also the main political parties at the political level didn't engage in these kind of debates. And it's possible that this has now backfired and is going out of control a little bit, and we now have forces which don't want any vision of European integration. So I think it's of utmost importance that scholars start to respond and discuss these issues. Thank you.